Good evening and welcome to Lawline. Lawline is a live call and talk show brought to you by the attorneys of Levin, Papantonio, Thomas Mitchell, Exner, and Proctor. We, the attorneys of the firm, bring to you Lawline to discuss on-the-job injuries in the state of Florida, Social Security disability, and personal injury. These are going to be our topics for tonight's show. My name is Brett Vigotsky. I'll be one of your hosts for tonight's show along with my co-host Aaron Watson. Aaron, how you doing tonight?
Doing pretty good. Glad to be here.
Well, good to have you on tonight's show.
Oh, yeah.
It's nice to have a colleague on the show, so I'm not flying solo tonight. But anyway, seriously, folks, just mention to you, we'll be discussing tonight is on-the-job injuries in the state of Florida, Social Security disability, and personal injury. Please give us a call. You can reach us locally at the studio at 432-7768. Or long distance, we can be reached at 800-950-2522. Whether you're an injured worker and want to know what your rights or responsibilities are under the workers' compensation law, if you're an employer or a business owner and want to know what your rights or responsibilities are under the workers' compensation law, if you're somebody that has been involved in a motor vehicle accident and want to know what you're entitled to under that statute, or somebody who has been injured and not necessarily on the job or suffer from a severe illness and think you may qualify for Social Security disability benefits. Any or all of the above situations, if you think those apply to you, tonight is your night to call in to get free legal information regarding any of these topics. Now, as I like to point out at the beginning of each show, Lawline is a participation show, which means, in essence, the more of you that call in, the more I can guarantee you will get out of tonight's show. Don't be afraid. No question is a dumb question. Give us a call. It's usually best to call at the beginning of the show because, as is the case right now and is typical at the beginning of the show, we have 3 open phone lines. Don't wait till the end of the show where everybody's trying to call in to get their questions asked and answered. Right now is a good time to call in. Just to remind you, the numbers are up on the screen. We're locally 432-7768. For long distance, we can be reached at 800-950-2522. Give us a call. Aaron and I would love to help you out tonight. Okay. While we are waiting on some callers, Aaron, let's just talk about kind of some basics. When somebody comes into your office involved in a motor vehicle accident, what are some of the first things that you look for as far as, whether or not you think that they've got a viable case to pursue on behalf of them?
Yeah, I want to say the first thing that I ask as soon as they come into my office is, I want to know everything that happened, everything from beginning to end. A lot of times clients, they don't want to, tell the entire story because they think that a fact is not relevant or it doesn't apply to their particular case. Yeah. But I tell them, I want to know everything from the beginning to the end, what happened. Usually they'll start, I was driving or I was at a red light. A car rear-ended me, while I was driving, a car sped right in front of me. So usually with those automobile accident cases, I get down to what happened, who was ticketed, was your seatbelt on? Was the other driver, the defendant driver or the at-fault driver, did they receive a ticket? And that's really good evidence of, I guess, liability, who's at fault.
Right.
After that, I guess the next question I would want to know is, usually when there's auto accidents, there's insurance companies that are involved, and a lot of the times insurance companies, especially when you have an at-fault driver, they'll try to contact you. They'll try to get as much information from you as possible. What happened? They'll try to get you to do a recorded statement. And keep in mind that these insurance companies, they have adjusters, and the job of the adjuster is to I guess, help the insurance company as much as possible. The job of the attorney, my job, is to help the client as much as possible. To make sure that her case is that she gets the most compensation that she can for her case. But I always tell my clients, or I ask them, have you spoken with an adjuster? Have they asked you to give a recorded statement? Have you been in contact with the at-fault driver? 9 times out of 10, a lot of my clients, and I'm very proud of them, they're pretty, smart. They'll say, listen, I got a call from this insurance company, but I didn't talk to them. I wanted to come to your office first, and I always give them a high five or a round of applause for doing that.
Decline the recorded statement so they don't tell the adjuster something they shouldn't be telling.
Yes, because that recorded statement, when you give that statement, you can't take that statement back. They're going to have that statement in their files, from the beginning to end. And when they take their statements, they're going to ask you questions that's going to help their case.
Not that they're trying to hide anything from the adjuster, but you just, there's certain rules of evidence that the adjuster shouldn't be asking. And
Definitely.
So you want an attorney there to monitor this.
Definitely. And I also tell clients that, say, for example, you get into an accident tonight. You go to the hospital, and that night you might say, "Oh, I had neck pain." The adjuster calls you the next day, and you still have neck pain. And so you say, when the adjuster says, "So what are your injuries?" Well, it's I have neck pain. Well, 2-3 weeks down the line, you begin to have back pain, lower back pain, upper back pain. Maybe some lower leg pain, tingling in your fingers, in your arms, numbness. Well, the adjuster is going to say later down the line, "Well, listen, I called you the day after, and you told me that you just had neck pain. So clearly, I don't know if you're making this up or where do the other injuries come from."
So she'll be looking to try to possibly exclude the upper back pain and the leg pain and anything else.
Because that's their job. The more injuries you have, the more they're going to have to pay. The more they're going to have to compensate you. So the first thing they want to do is they're going to call you and say, "Oh, what were your injuries?" Now, and it's not your fault. Your body, 3 weeks down the line lets you know that there's a problem with your back. You can't control that, If your neck's hurting at the time, you're going to tell the adjuster, "My neck's hurting." But they're not going to take 3 or 4 different statements from you. They're going to stick with that first one that you gave and say, "Listen, you know what? We're going to compensate you for your neck injury." And I tell you, that's part of my job is when in the event that happens, we're not saying that if you give a statement to an insurance adjuster that you don't have a case. That's not the case at all. If you have been in an accident and you gave a recorded statement the day after, that's fine. You come and talk to me at my office, and what we have to do is, get that adjuster on the phone and say, "Listen, my client has lower back pain, upper back pain, tingling in the fingers, and it happened as a result of your client's or your insured's negligence." So that's when we have to step it up, and really advocate on behalf of the clients and say, "Listen, my client has suffered this because of your driver's negligence, because he ran the red light, because he wasn't paying attention." So we advocate, we have to step it up with the adjusters. But to make everything go a little bit more smoothly, we say, when you get into an accident, call us, get an attorney involved. We don't mind giving a recorded statement, but we want to make sure all the I's are dotted, all the T's are crossed before that statement is actually given.
Let me ask you, what do you do? Let's say somebody comes into your office, gives you all the facts. The injury happened 6 months ago. They're getting a lot of treatment. They've seen a pain management doctor. Doctors referred them to a surgeon. Looks like they may need surgery. So looks like there's going to be some serious medical bills here involved. And when they first come and see you, 6 months into the accident, you find out that the at-fault driver's only got $10,000 in coverage. What do you do then?
Well, the first question I want to ask is whether or not the client has exhausted their PIP benefits. And basically, under Florida law, if you have an insurance policy, they're required to have at least $10,000 to cover your medical expenses, 60% of any lost wages. So the first thing I want to know is, did you put your own insurance company on notice that you've been in an accident? Because by law, they're required to pay that $10,000. And I get clients all the time that say, "You know what? Well, that guy hit me. Why do I have to let my insurance company know?"
They don't realize that theirs comes first.
Yes, your insurance company comes first, And the thing is, you pay your insurance company to step up and say, if I do get into an accident, that you're going to cover me. You're going to step up and you're going to help me out with it. That's why you pay your